to Shri Ramarao Garu. I request Madhavi Garu, member of the Bar Council, to come over the dais and adorn the chair. I request our fellow student member to present a sampling to ma'am.
Thank you everyone. Now, it's an honor to welcome Justice Nageswararao Garu, former Judge of the Supreme Court of India. Sir, pursued his BCom and BL degrees from Nagarjuna University, Guntur. Enrolled as an advocate with the Bar Council of Andhra Pradesh on 29 July 1982, he began his legal career practicing at the District Court of Guntur from July 1982 to January 1984. He then shifted his practice to the High Court of Andhra Pradesh at Hyderabad, where he continued from January 1985 to December 1994. Sir brings with him decades of distinguished experience at the bar and on the bench. Elevated directly from the bar to the Supreme Court in 2016, Sir has served the nation with exceptional insight and integrity till his retirement in 2022. Sir has also served multiple terms as an Additional Solicitor General of India, and we are privileged to have him speak today on the doctrine of judicial precedence and its binding nature, a subject deeply connected to the consistency and authority of our legal system. Apologies. Sir is going to present on a presentation on an art of advocacy in an ever-changing landscape of legal field. May I now request Sir to kindly take the podium and commence the session. Thank you.
Actually, last year when we had the seminar, the orientation program for the advocates, the same day was addressed by Ms. Nageswararao. But same day you are come, sir, last year, same day, and nice discussion, various subjects along with you. After a year, we are gathering here from KL University to Vijayawada, just jump to Vaishya. Hope so, and then also we will have some discussions on some other subjects. Thank you, sir. Please.
అందరికీ నమస్కారం. I might be speaking in English as well as Telugu for your convenience. I think that will be better. How many of you practice exclusively in the High Court? Can you please raise your hands? I see only about 10-15 people, so I'll have to address lawyers practicing in the district courts. I think that would be appropriate, because when I'm asked to speak about advocacy in the changing legal landscape, I have been an advocate for a long number of years, till about 2016, till I became a judge for about 6 years. Constitution permits only judges who are retired from the High Court to practice law in the Supreme Court. or in the other high courts in the country. There is a bar for us to practice. So we cannot practice anywhere in this country, either before the tribunals or before the courts. This has been troubling me. Recently I was doing an arbitration in Delhi. I saw Justice Nagarjuna Reddy walking in with some other lawyer. I asked him, have you come to conduct an arbitration here? He said, I've come to argue an arbitration as a lawyer. I felt very envious. Nagarjuna and me started practice at the same time in Hyderabad. Nagarjuna has the facility to argue again as a lawyer, which facility I don't have. I am searching for opportunities to appear before international courts, commercial courts, either in Singapore, London or Dubai, because there is no bar for that. I want to break the ceiling. No retired judge of the Indian Supreme Court has done this. Why I am telling you all this is, advocacy is very close to my heart. I never wanted to become a judge. I was almost forced to become a judge because I said no twice and I thought destiny was chasing me. I think life is like that. You want to do something, but the Almighty thinks of something else for you. Even when I was a judge, I used to dream about arguing cases. I once had a dream where I was arguing before Justice Bhanumati, who was still a judge then. And Justice Indu Malhotra was briefing me. And Justice Bhanumati was asking me, how can you appear? You are a judge of this court. Then I told her, the Constitution has been amended and judges are also permitted to argue cases. It is happening in several parts of the world. In Korea, after retirement, a Supreme Court judge next day goes to court and argues cases. There is absolutely no problem for them. It's only in common law countries that judges don't argue with the courts where they have practiced. The reason for my telling you is that advocacy is something which is very exciting. A person gets some sort of a strength when he wears a black coat, not for the purpose of fighting with police and then trying to escape traffic police. No. Not for that. But there is some power that is given by a black coat and the bands that you wear. At least I was feeling it. Every day when I was walking to court, I used to get a lot of confidence in myself. Not being an ordinary individual, you're something more than an ordinary individual. There are so many professions. You have engineers, you have doctors, they're also very good professions. But a profession which has so much strength is lawyering in court. You want to become a good lawyer, you should think about first that you have to get competence to go and then argue matters. How do you do that? That comes with training. Where do you get the training? Training initially is in law colleges or the law universities, which tell you the basics of law, and then thereafter you're out for yourself. The old practice was that everybody was going and joining a senior's office. They are working there for about 4 or 5 years, and they learn the tricks of the trade, lawyering, ethics. All these things are taught by the seniors, and then they upgrade themselves into independent practice. I don't believe that's happening anymore. I think lack of seniors or good seniors, whatever be, I see a number of youngsters starting professions straight away, even without having that formal training before senior advocates. I would still recommend youngsters who are coming out of college to have guidance from a very good senior in whichever place you are practicing. You will learn so many things because which are not taught in colleges. Colleges don't teach you everything about practical lawyering. So you have to have training. In foreign countries, continuing legal education is compulsory, which means that once you start practicing, you don't need to learn law. That's what we practice in India. We think that once we wear a coat, we got to get another license, then we need not learn, we need not read. We can practice for the next 40 years, 50 years without even opening books. That's the general feeling we have here. Continuing legal education is compulsory in advanced countries. In the UK, you have 4 inns where barristers get their degrees. They have been operating for the past 500-600 years. Even solicitors also get their training and then get a certificate to practice in UK. All these inns, which are Inner Temple, Middle Temple, Grace Inn, Lincoln's Inn, they have their own continuing legal education programs. And all the inns together have training for advocates. It's called Inner Courts Compulsory Education. I think if you can check it, you'll get it. ICA, I think, is the academy, Lawyers Academy. People go there by paying money. There's nothing free there. But everybody wants to be trained as an advocate before they start practicing or continuing to practice. I was thinking, what do I speak when I was asked to speak about lawyering in a changing legal landscape? I initially thought that I should tell you about lawyering in the first place. So I just went to the ICA website and I was seeing what is it that they were speaking about advocacy, which we don't know. So I was actually very impressed by seeing a video. Now all of you have mobile phones, internets, you might be very savvy with computers. I would recommend that if you go, you will get videos there as to what lawyering is all about. There's a 1-hour video where there's a discussion of basics of lawyering. It is the same. It's the same law that we practice. We follow the same principles of UK. We follow the common law principles. The basic thing that is spoken is that you should prepare, and prepare. Three times they say prepare. And what is said is that when a brief comes to you, you should read it 3 times. One general reading for understanding the case, and then you read it. While you read it, you think about what the other side's case is about. If you're practicing in a constitutional court, even the judge is the other side. Because the judges keep asking questions. So you keep judge in your mind when you read. And what would be the other side's case. And the third time you read it on behalf of your client. What would be the strength of your case and then how is it that you can present your case. My own personal experience, if you ask me, as and when I was reading my briefs while practicing in the High Court for 10 years and later in the Supreme Court, I used to have an inset of the judges in my frame when I was reading. I used to keep thinking, what is the judge going to ask me? How intelligent is he to understand everything? What sort of arguments should be advanced before him? There are judges where you need to be slow. There are judges before whom you can be very fast because they have read the papers, they know everything. There are judges who need to be persuaded when you are arguing. There are judges sometimes where you need to stop them from asking too many questions. There are more rambling judges in this country. So, having a judge in your mind is a very compulsory thing when you prepare the case, apart from the other aspects. You prepare a case and then go argue before court. As I see from my own personal experience is this. Ethics is a very important part of profession. Integrity of an individual is something which you cannot negotiate. Every person who joins this profession wants to make this a career. A career is not like business. This profession is not business. If you want to make only money and nothing else, I think you shouldn't join the profession in the first place. But mind you, I'll tell you that if you don't think about money, you only think about being a good lawyer. I will not use the word successful lawyer, because success nowadays is in terms of the money that you earn, the number of cars that you own, the number of houses that you have. I only say that you want to become a very competent and a good lawyer. Once you succeed in making a name for yourself as a lawyer, money flows. Even you would not know the amount of money that you're making once you succeed as a lawyer. But if you start working for money, you're only making money and not a name as a lawyer. There are so many people in your profession and outside who will not recognize you as a lawyer, a good lawyer. They say it's all right, you'll also make money. So please don't join this profession for money, and if you still think that I want to make more and more money, I would say that you should go and do some other business. The third time when I was offered judgeship, Justice T.S. Thakur asked me, what is it that you have not done? Why is it that you don't want to become a judge? Then he said, if you are thinking in terms of money, even a scrap dealer makes crores and crores of rupees. So he said there's something that you have to give back to the society. I'm using this only for the purpose of saying money is not important at all. It is a consideration. You will also have to live. And while living, you should live a decent life. You have a family to take care of. You have children who have to be educated. All these taken into consideration, but you should not think about the other council has 2 cars or one council has a bigger car, I don't have one. I think please don't go by this consumerism. This actually leads you away from the path of rectitude. And as I said, ethics is very important. Ethics, when I speak of ethics, I'm not going to give you a class on morals. I'm only going to tell you that every one of us know what is right and what is wrong. It's just a matter of comparison. I might be able to justify myself tomorrow. You said most of you are practicing in the district courts, you might be practicing in the criminal side. You must have met a number of clients who have come to you. Every person has a justification for what he has done, including a grave crime. So there's nobody, very few people who say that I've done it and then there's remorse. That will not happen. Likewise, every human being has a justification for what he does. I might say it's all right, everybody is doing it, the world is like this, so I'll also do it. But let us make the change. All of us, I think, have to decide that we are in some sort of a profession. I'm not going to use the word noble profession. You must have been hearing it from the day you joined the profession. I'm not going to pitch it that high that it has become very noble, but at least this is a profession which is very, very important in imparting the justice in this society. The only institution that people have confidence is the judiciary now. I'm not saying judiciary is doing everything right, but I'm only saying that people still have confidence. And if the confidence in judiciary is to continue, it is on your shoulders. It's only the lawyers who can impose confidence in the public that I'll get justice. If I go to court, I need not go on a different route, or I need not go and then settle it through a panchayat otherwise. So integrity is something, ladies and gentlemen, please remember that you should not sacrifice integrity. When I said integrity, integrity is your character. It is not waving, not going outside the path of rectitude. Don't be corrupt. Don't encourage anybody to say that I'm going to pay some money. Or don't corrupt anybody by, don't hear anybody, or don't let the clients tell you that you can manage a judge. Or otherwise you can manage the other side lawyer. This is what we keep hearing outside. You go to a society of people where there are no lawyers or judges, we don't have a very good name. Actually, we are, I think, compared to scorpions and snakes. That's the reputation of lawyers. I remember Justice Kodandaramaya, who is Justice Narasimha's father, telling me initially when I started my practice. I met him long number of years back. He said that he went to Varanasi, and then when he went to Varanasi, he was a person, though he shifted to Hyderabad, he was not very familiar with the language of Hindi. So he was finding it very difficult to communicate with people there. And then the only thing that he could communicate to them that he is a vakil. So he was given a lot of respect in Varanasi only because he told them a vakil. Till then nobody was even looking at him. So he was telling me that's the respect that an advocate gets. But are we getting the same respect now? I'm not sure. If you go to the society and then say, don't wear a black coat, just leave it and then say I'm a lawyer. So without any fear, I don't think we get any respect from the people. All this is only because the general opinion of the public being that we are all persons who do not have integrity. That has to change, and that change has to come only from us. Because the interface of the judiciary with the public are lawyers who are practicing in the district courts. People in the high courts might be meeting a few lawyers, but otherwise you are the people who actually exchange your views, interact with clients. Their opinion about the profession comes from you, the way you behave. So ultimately you are the most important persons who will uphold the good name of the judiciary. So much on integrity. I will now leave the topic of integrity. When you speak of lawyering, I haven't come to the changing legal landscape. When you speak of lawyering generally, you talk about preparation, you talk about cross-examination in courts, you talk about drafting, you talk about hearing. These are things which normally you do. So how to prepare a case, I told you that you might have no shortcut except to do some hard work. When I say hard work, I have seen the people working for 14 to 16 hours every day without doing anything else and still not being able to be successful lawyers. See, there should be a break, and that break comes in everybody's lives, and this break also makes ordinary people great people. If Mahatma Gandhi was not thrown out from his railway compartment in Bloemfontein in South Africa, he would have been actually practicing there. He was doing very well as an advocate in South Africa. All of you know that he purchased a first-class ticket and then he was not permitted because he was not a white. And there he thought, why is discrimination? And that's where Mahatma Gandhi started thinking that he has to come back to India. And after he came back to India, everything is history. So Mahatma Gandhi was such a great person who led the freedom movement. Likewise, there was another lawyer, I'm only talking about the lawyering community, who was having a good practice. He was really not bothered about what was happening, he was making good money. One day, he saw a leper who was being mistreated by everybody. You see a leper and people will start running away. And nobody was even taking care of the leper. So he saw that, and that incident changed him. And he became Baba Ante. He left the profession. He was only working only for people who were having no privileges at all. So there are certain incidents which will change life. There is one case that might change your life. So when is that case coming? For some people it comes within 6 months of their joining the practice, they're very lucky. For some people it might take 3-4 years to come. I'm not talking about one case which leads to a number of other cases rather. But would you be ready when the case comes to you is the main question. Somebody comes to you and then says that I want you to file a case, whether you are ready to draft, whether you are prepared to go and argue. So initial days of the profession, I would say that each one of you should be ready to handle matters that come your way. I have practiced for 10 years in the High Court before going to the Supreme Court. I was doing reasonably well as a lawyer in the High Court. I had sufficient number of cases. But when I went to the Supreme Court, I found that I know nothing about constitutional law. What I knew was only speaking English and then writing a few sentences correctly. Whatever I did for 10 years was really not sufficient. So if I had to compete with competent lawyers in the Supreme Court, I had to prove myself. The initial 1 year of my practice in the Supreme Court was spent mostly in the library and the consultation rooms where I used to sit and read. I started reading from the fundamental chapters, fundamental rights chapter onwards, and I read almost all the books on constitutional law in that 1 year, apart from various other laws because I was getting some cases. Whatever I was thereafter, I had a reasonably successful practice in the Supreme Court. I was lucky in getting breaks, but when I got that break, I was doing well as a lawyer. That is the reason one case led to two cases led to 20 and 200 or whatever. I was so fortunate in appearing in almost all the high courts in this country. Most of the judges before whom I appeared were my junior judges when I became a judge. And most of the judges before whom I have appeared are in the Supreme Court or in the high courts. All this is because I was fortunate in getting cases. That's not sufficient. All this is because I also worked very hard. So when the case came to me, I had to do well. And for doing well, I had to prepare. When I prepare, I'm not a genius. I'm not very intelligent. I keep telling everybody I'm not as intelligent as Justice Rohinton Nariman or some other judges who are brilliant. What I used to do, which I learned from Mr. P.P. Rao, I don't know whether you have heard the name of Mr. P.P. Rao. He was a brilliant lawyer, a senior advocate from Prakasam district in Andhra Pradesh. He didn't practice like me in Hyderabad. He was in Delhi, he was teaching law in the Delhi Law University, and thereafter he became an advocate on record. He was an advocate on record for the state of Andhra Pradesh, became a senior counsel, and he argued several important matters, including constitutional questions of law. Whenever we used to go to brief him initially as junior lawyers, he used to write notes. You go the first time, you weren't then brief him, he used to write notes. He used to call his stenographer and dictate. You go the second time, after notice is issued, the matter comes up for hearing, you go and brief him again, he used to write notes again, call the stenographer. So I asked him once, in the normal course, you write notes once, and thereafter when the matter comes, you read the notes and then go and argue. So he said what I just told you. He said that I am not very intelligent like others. I make it up by reading a brief 4 times, 5 times, at least to reach the level of the other people. But that definitely makes you more prepared and more confident to argue in courts. That's what I used to do. I used to read briefs more than required. So anybody and everybody who's here, you said you're practicing in district courts, you might be coming from Mofsal areas. I'm from a very small village. So for me to have gone all the way to Delhi, became a Supreme Court judge like Justice Ramana or like Justice Chalmeshwar or some other judges who are coming, Justice Narasimha. He became a judge not on the basis of his being a judge's son. He did all by himself. He was practicing in the Supreme Court because I know Justice Narasimha from the day he started the profession. So everything is self-made. The person has to do everything on his own. Here, there is nobody who is going to do anything for us. Each one of you is operating in silos. So only a few people might be having somebody trying to promote you. But most of us don't have anybody to even promote us. Each of us has to promote ourselves. And the recognition should come only from merit. So what I would say on this topic of how to be prepared in a matter and breaks coming your way, I am sure that everybody gets a break. I am sure that each of you, if you work hard enough, will be doing reasonably well. You can't compare yourself with somebody else who's doing extremely well. That's only going to give you some sort of a bad feeling. You should be happy with what you are, and then you should try to improve yourself. You should try to improve yourself more as individuals than as successful lawyers. You should be a good human being to be a good lawyer, and thereafter you become a very good lawyer. So after this preparation, you have been having all these cases so many years. You have been after independence, you have been seeing civil law, criminal law. These are the two things mostly which you do in the district courts. Now, when you speak about this changing legal landscape, how is it changing? I've been seeing it changing for the past 30 years, especially during the past 10-15 years. You had the Commercial Courts Act, which has been promulgated in 2014-15 or whatever. So, this Commercial Courts Act was made after discussion for about 10 years. In 2008 there was a proposal, but ultimately it took shape only in 2016 or 15, I'm not very sure. The idea is that even at the district court level, you have commercial courts which would be definitely different from the civil courts which are already there. All the commercial matters will be decided fast because we want to improve ourselves as a big economy. We're already the fourth largest economy, you must be knowing. So, commercial matters are some branch of law which I think people should think about. They're not different from the regular matters that we were doing earlier in civil courts. They're only different because of the commercial angle given to it. Nowadays, you speak about commercial courts and commercial matters being a different branch of law. Arbitration is something which is connected to commercial courts. All of you must have heard about arbitration, but I'll tell you some give you some very interesting information about arbitration, and then how the perspective in India is and how well it is in the world outside. Because after my retirement, I'm doing only arbitrations and I'm doing international commercial arbitrations. The perspective of advocates in India who are lawyers in arbitration and judges in India is completely different from what it is outside. Arbitration is, if I can use this word, some sort of an activity which a lawyer does after finishing court work. You want to do litigation, your main job is to go to court and argue cases. Whenever you find time, it's alright, I'll work in the evening also, I get some extra income by going and appearing in arbitrations. That's what arbitration lawyers do in India. Insofar as judges are concerned, their problem with arbitration is they do so many other things. Arbitration is only one branch along with so many cases that the judges deal with. You take High Court judges and Supreme Court judges. There's no choice for a High Court judge or a Supreme Court judge to say that I will only do one branch of law. So for a month or two, they will be doing criminal cases. For a month or two, they will be doing civil cases, otherwise arbitrations, taxation. They're mostly interested in constitutional courts are interested in upholding constitution, liberties, rights of individuals. So their perspective is only to learn more about jurisprudence relating to constitutional law. And they'll be thinking about administrative law, corporate law, they'll be thinking about so many other things. Arbitration is only a small branch. So they don't have the time to really understand what arbitration is about. Arbitration itself is a wealth of knowledge which you have to learn from. What I've seen after my retirement is that being an arbitrator here in India is different from being an arbitrator outside in international arbitrations. I will tell you about lawyers from India, youngsters who have passed out law from India. There are in hundreds outside this country who have gone. Let me tell you about London. In London, there are a number of lawyers who have gone there and qualified themselves to practice in London, or otherwise they're doing arbitrations. I've spoken to two persons who are extraordinarily intelligent. One person's name is Dipen Samarwal. He's from Lucknow. He studied in the National Law School at Bangalore. He wanted to start practice in the Supreme Court. He comes from a middle class family in Lucknow. He told me that he came to Delhi, then he thought that he will not be able to survive in Delhi because he didn't have the financial wherewithal to take a house and rent a small house and start practice and wait for 10 years, 15 years. We do not know when a person will start getting work. So he thought, okay, let me get out of the country and then do something. He went to White & Case, is one of the largest law firms in the world in New York. They have branches elsewhere. He went and joined there as an intern and became a partner. At the age of 39, he was given a silk in the United Kingdom, that is a senior counsel. The top counsel in India, Harish Salve, he shifted to London about 15 years back, and he almost fought for about 10 years to be given that silk, becoming a King's Counsel. Earlier it was Queen's Counsel. Here in India we call it Senior Advocate. So at the age of 39 he became King's Counsel. And he is doing extremely well as a senior partner in White & Case in London. I asked him, why did you go away from India? He said, sir, I'll be very frank with you, that I found that surviving in the profession in India is very difficult. Number one. Number two, he said, I don't like to say it in public, but I will repeat what he said. I'm definitely not going to be held for contempt. He said at least 85% of the judges in India are either inefficient or incompetent. See, this is the reflection of a young lawyer or his feelings. Then I was thinking, when he said inefficient, he was not demeaning any judge in India. He thought that the level of intellect in the judiciary is lacking according to him. There is another person by name Niranjan, who is even younger to him. He was working with Mr. Arvind Datar. I don't know whether you have heard his name. Arvind Datar is a senior advocate who is practicing in the Supreme Court. He is from Chennai. He has old parents. He wanted to take care of his parents. He did not want to shift outside the country. But he was suffering because he is an extraordinary lawyer. He has photographic memory. He was suffering because he was not getting a chance, and whenever he was getting a chance, he found suffocated because he was not able to really succeed in the profession and making judges understand what he was saying. So Arvind Datar suggested to him, I think you're wasting your talent here, get away. And his parents also said, it's all right, we'll take care of ourselves, you can keep coming and going and go. He shifted to London. And then after completing only 9 years in London, he was made a King's Counsel recently, 3 months back. So even he is of the opinion that he would not have succeeded in this country. And there are hundreds of people who are going. Is this justifiable? According to me, it is not. This is brain drain. See, you study here and then go out and then your intellect is not being used by this country. That's not correct. So you'll have to stay back and then prove yourself. You'll have to withstand the competition and then succeed here. Good luck to them, they've gone out. We have enough number of lawyers here. I'm told there are 50,000 lawyers in Andhra Pradesh. So by their going away, nothing is going to happen to this country. I'm not saying anything against them here. But I'm saying that if you are a person who's competent, stay back here and prove yourself and change the system if you can. That's what we should do. So I will come back to where I started in arbitration. I said that when we are speaking of a legal landscape, what I'm trying to tell you is, in this country, petitions under the Arbitration Act for setting aside the awards are filed in the district courts. All of you must have argued these petitions filed under Section 34, Section 9 for interim orders. So most of you must be aware of the Arbitration Act. Arbitration Act is very paying in the sense you are not dealing with people who do not have money, you're dealing with businessmen, you're dealing with people who are investing money. So if you are to become a good arbitration lawyer, then you might have to get good training in arbitration. There's one aspect which I want to tell you here. There is a serious roadblock in our minds. When we think that we have finished law, we think that we don't need to learn anything. I already mentioned it to you. This is a problem not only with lawyers, this is a problem with judges also. Judges cannot be told that they should be trained. It will be an offense. You go and tell a judge you have to go out for training. So we use the word orientation. Let the judges go for orientation. See, High Court judges go to Judicial Academy at Bhopal for their training in various subjects, each course. Supreme Court judges, they don't go anywhere at all. They don't need training because they become gods. I use myself, we have become gods. That's what we feel. That's not correct. Last month I was in Bhutan training advocates to become arbitrators. I went with an international contingent of people from Singapore and London. We trained lawyers there for 2 days. Half a day, we were asked to go to the Supreme Court and speak to the judges there. And I was asked to take the lead by the other members who were not judges but who were only arbitrators. I asked them why. They said, judges will only listen to judges, they will not listen to other people. So I went there and then spoke to them. I found them to be so modest. At the end of the day, all the judges walked up to me and said, sir, we want more orientation. Because we didn't know that there's so much outside Bhutan. Bhutan is just developing as an arbitration jurisdiction. They said, please let somebody come and then we will attend the training course. I said, this will definitely not be the sentiment in India. If I asked the Supreme Court judges, you also have to be trained, they would have thrown me out. So there are people, even at an elderly age, who want to learn. There is absolutely no stopping learning. Even we learn all the time. Even at this age, I learn. There's so much to learn. I keep telling myself, I don't know anything. So that's the only thing that keeps everybody going. If you think that you know everything, you'll stop learning. So as I was talking about arbitration, if you think that it's all right, I've seen the Arbitration Act, I know everything, that's not correct. I think you'll have to think about if you want to become a good arbitration advocate, for which there's a lot of scope, not only in domestic arbitrations, even at the international level. You should start attending courses. There are online courses now, you need not travel anywhere. So if you can, go to your internet and then see who's offering these online courses. Then you'll start learning. So when you get some work, you would definitely be noticed as somebody who knows more than the others. How is it that a person succeeds in the profession? When you are on the stage where you are performing, how best you can do it is the question. I was just telling you about Justice Nagarjuna Reddy, he has come. So I... To repeat what I said, నేను చెప్పానంటే ఓ 2-3 నెలల క్రితం నేను ఢిల్లీలో చూశాను. నేను నువ్వు ఆర్బిట్రేషన్ కండక్ట్ చేయడానికి వచ్చావని అనుకున్నాను, కానీ నేను అడిగితే నువ్వు కేసు ఆర్గ్యూ చేయడానికి, ఆర్బిట్రేషన్ ఆర్గ్యూ చేయడానికి వచ్చావంటే నాకు చాలా బాధ వేసిందని చెప్పాను. నువ్వు ఆర్గ్యూ చేస్తున్నావు సంతోషం కంటే నేను చేయలేకపోతున్నాను బాధ. That's what I was telling them. I took the liberty to take your name. As I already told you, we have been friends for such a long time. We started practice together in the High Court. I just took that incident to say that advocacy is something which is very close to my heart. Even today, I feel bad that I'm not able to argue cases and చెప్తా ఉన్నాను. And I was trying to tell them how gifted they are to be advocates, and what is it that they have to learn to become successful advocates. So as I was speaking about arbitration, I would suggest that all of you go to the internet, find out where you can get some information, where you learn advocacy. There is another branch of law which is very important now when you're talking about the changing legal landscape, which is mediation. You must have all heard about mediation. Practicing mediation is very difficult. Everybody thinks that mediation is very easy. ఏముందిలే ఇది పంచాయతీ కదా వాడిని తీసుకొచ్చి కూర్చోబెట్టి మాట్లాడు 2 మాటలు వాడు ఎవడొకడు ఒప్పుకుంటాడు. లాట్ ఆఫ్ సైన్స్ టు మీడియేషన్. Mediation in this country is necessary. Why is it necessary? Because we have more than 5 crore cases. ఇవి ఎప్పుడు పోతాయి? నీతి ఆయోగ్ చెప్పినట్టుగా 326 సంవత్సరాలు పడుతుందండి ఇది అవటానికి. సో ఈలోపు మనం ఉండవు, మళ్ళీ దాని తర్వాత ఇంకొక 5 కోట్లు యాడ్ అవుతాయి దీనికి. సో ది ఓన్లీ వే దట్ dependency is reduced is to promote mediation. And we have been doing so many things for the past 20 years. Mediation promote చేయడానికి recently we got that Mediation Act also promulgated. Most of the provisions are not notified. But mediation as a profession is something which lawyers do not know in this country. Mediation is always a pro bono activity. Judges గా ఉన్నప్పుడు హైకోర్టులోను సుప్రీం కోర్టులోను ఆ కోర్టులో ఉన్న సీనియర్ అడ్వకేట్ని కెన్ యూ ప్లీజ్ మీడియేట్ అని పంపిస్తారు. హైకోర్ట్స్ అండ్ సుప్రీం కోర్ట్ హ్యావ్ mediation centers. Mediation centers have trained mediators. According to the MCPC, which is the Mediation Conciliation Project Committee, 40-hour training is necessary for mediators to be on the panel. That's a minimum. And then you have 10 mediations which you should do to be on the panel. A trained mediator would make much of a difference insofar as mediations are concerned. Now, what is happening in the district courts? All of you are aware of what I'm going to tell you. Referral judges are not trained in this country. Referral judges are judges who are dealing with your civil cases. Section 89 CPC says that before starting trial, a civil judge has to explore the possibility of sending a matter either for mediation, arbitration, or judicial settlement, which normally is not done because referral judges are not trained, number one. Number two, I was speaking to some district judges some time back as to why referrals are not happening from the district courts. They were saying that there are not sufficient number of trained mediators in the districts. So they say even if we send these matters for mediation, they just come back because advocates don't take too much interest. Why are they not taking interest? Number one, the money paid to these mediators is very less. Number two, mediation is not taken up seriously. Number three, those mediators who are trained are not properly trained. There are certain organizations which give a certificate after training for 1 day or 2 days, that is 6 hours, 8 hours training. That is not sufficient. I am told that the Chief Justice of Andhra Pradesh has taken interest in ensuring that all referral judges are trained. Yesterday I was speaking to a district judge from Visakhapatnam. Then he told me, Giridhar, he is now in VAT tribunal, he told me that most of the referral judges have undergone training. And here in this state, what is left is training of advocates as mediators. So who are going to do it? MCPC was doing it. The Chief Justice also took steps in this. Hariharnath Sharma, who is now a High Court judge, when he was in the academy, he took a lot of interest, is what he told me, in training mediators. Let me tell you, mediation as a profession is lucrative. Right now, no, in India. Outside this country, it is. You have mediation bars, and I am told by people who only do mediations, nothing else, as lawyers, they make equal amount of money as people in litigation. లిటిగేషన్లో ఎంత డబ్బులు సంపాదిస్తున్నారు అంత సంపాదిస్తున్నారు. ఎందుకంటే పేమెంట్ అలా ఉంటుంది లాయర్స్ మీడియేషన్లో కూడా. మనం ఇక్కడ ఏమనుకుంటామంటే మీడియేషన్ అంటే నా కేసు పోతుంది అనుకుంటాం, ఇది సెటిల్ అయిపోతే నేనేం చేయాలి ఇంకా అనుకుంటాం. దట్స్ హౌ లాయర్స్ ఆర్ సీన్ టు బి ది విలన్స్ ఆఫ్ మీడియేషన్ ఇన్ దిస్ కంట్రీ. మీడియేషన్ is something which is to increase as a profession. Recently, I think last month, the mediation bar of India was started by the Attorney General. He is now the first president of the Mediation Bar Association. So the idea is now to ensure that lawyers take mediation as a profession and not an avenue where they lose work. See, even if I am a person who has 3 or 4 matters, and then if people say that these 3 matters can be settled through mediation, I'll think twice. Once these are settled through mediation, what do I do? But if you also take it as a profession, and then being a mediation lawyer also is paying, once matters are settled, there will be more people who want their matters to be settled, and then you'll get enough money or sufficient money as you are getting in litigation. Might not be if you are prolonging the litigation, but otherwise in the number of cases that you might handle, you will definitely be making sufficient money as a lawyer in mediation. Mediation lawyering again needs training. It is not done here. Mediators are trained. Mediation lawyers are not trained because you don't have sufficient training institutions in India. So there was a move in the MCPC when I was there, and thereafter Justice Sanjay Kishan Kaur also took it up. Earlier, what was being paid to a lawyer in the mediation committees for the high courts was a pittance, very less, 3,000 rupees or whatever. And then if the mediation fails, they don't give you anything. A successful mediation gets you 5,000. Now they've increased it, I think, to 7,500, 10,000. I was telling the present MCPC committee that you have to increase it further, make it a little more lucrative for people practicing in the district courts to spend their time as mediators. If you want to spend time in mediation, you should also get some money. So you can't keep wasting your time on mediations. So mediation is something which has to be promoted. Mediation is for the future. I'm sure once the Mediation Act is notified, where ఇప్పుడు వరకు ప్రాబ్లం ఏంటంటే, if 2 parties settle in mediation, these 2 parties are not sure whether the settlement is enforceable in a court of law. Because of the Mediation Act, it is like a decree. Once it is there's a settlement, you can go and then enforce it a decree. Nobody can go back on that. So there is some sort of an assurance that a mediation settlement also is enforceable. So I would request, or I would recommend all of you to take mediation seriously. You have to go through a 40-hour course. After my retirement, I underwent 2 40-hour course training in mediation. Not because I wanted to become a mediator or a mediation lawyer. There was somebody who started spreading a word that judges can never become good mediators. They only know how to shout at lawyers in court and decide matters, nothing else. So I just wanted to prove to them that that's not so. See, mediation is not adjudication, all right. But you cannot say that every judge is not a good mediator. They can be mediators also, because if lawyers can be mediators, why can't judges be good mediators? So that's the reason I went through the course. But I would recommend to all of you, please take mediation also very seriously. There will be training that will be available by the MCPC. I think the High Court is taking up, and at the district levels also the training would be there. And once training is imparted, and once you get training, you will become very efficient in so far as mediations are concerned. So I spoke to you about arbitrations and mediations, which are new branches. They have been there a long time, but there is a lot of scope for mediations and arbitrations as I was speaking to you. I also told you about some commercial law, if you can take up, that would also be good. But otherwise, lawyering actually hasn't changed much, merely because you have new branches of law. A person, to be a good lawyer, has to have all the characters which I just spoke to you for the past half an hour, 45 minutes I was telling you. One thing that every lawyer should understand is, first, you should not stop reading. Acquiring knowledge. Knowledge is not restricted only to law. Initially you have to learn law. But otherwise, reading is a habit which you should not give up. I will tell you about a few things which I know of, which have helped in a person becoming a good lawyer. I don't claim to be a very good lawyer, decent lawyer. When I was in college, my father used to ask me to read. He used to say, why are you not reading? Why are you not getting good marks? I was a very average student. The moment I opened the book, I used to feel sleepy. Very, very difficult to read. I think most of you might be facing it now. Or at least earlier you would have faced it. But once you start taking interest in reading, now I cannot stop reading. If I don't have work for more than 2 days, I feel sick. Work is only reading. You get so much pleasure in reading. You should enjoy reading. And then the knowledge that you acquire. Even in branch of law, I was just thinking what is interesting in law when you read. As I said, all of you have access to internet. Just look at the Socrates trial. 399 BC. Socrates was put to trial for impiety. Impiety ante nastikata. What was the charge against him? The charge against him was he did not believe in gods which all people in Athens believed. He used to argue a lot. The charge against him was impiety and spoiling or corrupting the minds of young people in Athens. Those days, there was a jury trial. 500 Athenians were brought. They were asked to find whether Socrates was guilty or not. 500 mandi. Jury trial later, a judge would be there to guide the jury in US or in UK in some trials now. There were no judges also. So Socrates, being a teacher and a scholar himself, said that I am going to argue for myself. So he had to argue before 500 people. And there is a small book written by Plato, who is his disciple, 15-20 pages, called the Apology. It's available on the internet. So Socrates argued, he said that, what are you trying me for? Just for expressing my views, merely because I don't agree with all of you. You can't try me like this. So he argued for about 2 hours, 2.5 hours. And thereafter, 260 people out of 500 people found him guilty. The remaining 240 people, I think it is 270 to 230, they found him not guilty. Then there was another voting as to what should be the sentence. And thereafter, around 300 people said that he should be sentenced to death. So the number increased. And then he was taken to a jail and then given some poison and then he died at the age of 70. This is not interesting. There is something connected to law. So there are so many stories in law which will really make a very interesting read. I don't know whether you have heard about a case which is a very famous case called the Bhaval Sannyasi case. Has anybody heard about it? I just said yes here one. Has anybody heard about Bhaval Sannyasi? There are books written in England about this Bhaval Sannyasi. Please sit. There was a person from a royal family. I think it is in 1905. He was born and then this was in the United Indias from the Bangladesh area. He was actually taken to Darjeeling for curing some diseases. I don't want to tell you. There's an allegation that he had syphilis. So he was taken to Darjeeling by his wife for treatment. And then he died. And his body was placed on the fire. And by the time they lit fire to the pyre, there was a dust storm, heavy rain. People started moving away from it. They went back to see that the body was not there. They thought it's all right, it is already over, and then they went back. And after about 15 years, there was a sannyasi who appeared on the streets of Dhaka. So he was just sitting in some place for about 2-3 months, and then people saw that this person appears to be like the person from the royal family. And then slowly they all promote him to be taken to the palace or whatever house they are. So he also says, yes, I am the person whom you are talking of. I fell unconscious. His case actually in court was different. And thereafter some Naga sadhus who were going, they took me, and then I was roaming around all over the country, and he came back. And he was not even speaking Bengali, he was only speaking Urdu. People said, what happened to your Bengali? He said, I forgot because I've been roaming around for about 15-20 years. So ultimately there was a suit for declaration that was filed. Because the Board of Revenue also was not accepting that he belongs to the royal family. Otherwise you would get, those days you know that the rents have to be paid by the peasants and landowners to the person who is a zamindar there. So he was getting money. So the Board of Revenue and the government said that we don't recognize it. There was a case filed for declaration. Ultimately it went to the Privy Council from a 3-judge bench of the Calcutta High Court. And the Privy Council held in his favor, and a few days thereafter he died. The fight was mainly for the property. After he died, there was a forensic examination. I think there would not have been forensic examination like now. Forensic examination, it found that he was the same person. So there are books written about this trial which was very interesting, which went on from 1933 onwards to the Privy Council. I think there's one book written there, I think a Living Dead Man or whatever, written by...
Sir, I read the Bengali version.
Okay. There's something written in England, there are 2 books. So it's quite an interesting case. I think you should read about this. Bhaval Sannyasi, this is much prior. There are so many, hundreds and hundreds of cases like this, which would definitely interest you. Does anybody know which is the last case tried by the jury in India? Right. Great. It is Nanavati. Can you tell me about this case?
The prisoner, he is the officer.
Come in. Can you give me a mic? Do I have time?
Yes, sir.
Briefly, I am aware of the facts. The facts of the case is that he is a naval officer. His wife is in an illicit relationship with some other person. He has taken his revolver from the what he calls service revolver, and he went there and he had shot that person. And later it was referred to the jury and a trial has been took place. This is the Nanavati's trial properly called.
You're right, but what is it that the court held in that case? You're right, what happened? He was convicted, conviction confirmed.
First he was acquitted, sir, by the jury. Later he was convicted.
And then conviction confirmed by
Yes,
Supreme
sir.
Court.
Conviction was confirmed.
And thereafter he was pardoned. It's alright, I will take it from there. He was pardoned. what was held, which is very important, is that we don't need jury trials, number one. And number two, an interpretation of section 300, like you see about sudden and grave provocation. That's the important point. His defense was sudden and grave provocation. The court said that it's not a case of sudden and grave provocation. But at least we got rid of the jury. Just imagine if we still had the jury and then all these criminal cases are decided by the jury. So
All politicians will go out.
people that's a good idea. So